Welcome to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin, along with Joe Bankman. Hi, Joe.
Hi, Pam. Pam, I grew up in LA in the 60s, and the air was always terrible. And every time I ran or exercised, my lungs burned.
And that's why you stopped doing it.
And that was true of everyone back then.
But it's not true today.
Now, the air has gotten just immeasurably better, and some of the cities that were obscured by gray smog are now resplendent, like Pasadena with all of its old architecture. And California has really led the way, along with some of the administrations at the federal level. But now the Trump administration has decided that at this point, maybe the costs exceed the benefits, and we ought to, if not roll back the clock, at least stop trying to improve things from the status quo.
And we have two guests with us today who know an awful lot about this and are going to help us understand kind of where things are, where they're going, and also a little bit about how Stanford's involved in these issues. The first of them is Debbie Sivas. Debbie is the Luke W. Cole Professor of Law at Stanford Law School. She's the director of the Environmental and Natural Resources Law and Policy Program, and she's director of the Environmental Law Clinic here. And finally, if that wasn't enough, she's also a senior fellow at the Stanford Woods Institute for the Environment, which is an interdisciplinary institute here at Stanford that studies a huge range of environmental policy and scientific issues. Ben DeGolia, who's also joining us, is a third-year law student here at Stanford. Last year, Ben worked in the Environmental Law Clinic, and we'll talk a little bit about that. And right now, Ben is researching whether the Environmental Protection Agency can revoke California's waiver under the Clean Air Act. And I guess maybe one place to just start is asking you, when I say that's what you're working on, what does that mean?
Well, it means that I'm doing a directed research project with Professor Sivas, in which I'm looking kind of at all angles of the EPA's authority to possibly revoke California's waiver.
So what's the waiver?
So the waiver is a provision in the Clean Air Act that under which the EPA, if certain conditions are met, must grant a waiver of preemption to California to set its own vehicle emission standards. So under the Clean Air Act, the federal government has exclusive authority to set vehicle emission standards, but then the Congress in the Clean Air Act included this provision that grants California a waiver of preemption if certain standards are met.
And that means California can set higher standards than the federal government.
That's right.
Okay.
And these standards, Ben, they turn out not just to be important for California, is that right? Because other states piggyback on them?
Yeah, that's right. So beginning in 1990, Congress amended the Clean Air Act to allow other states to follow California's standards. And today, about 15 states follow California's standards, representing 40% of the auto market.
And these standards do what?
So they regulate both traditional criteria pollutants like smog and other criteria pollutants. They also regulate greenhouse gas emissions. So beginning in 2005, California passed a law regulating greenhouse gas emissions for vehicles, which became a source of significant contention with the Bush administration.
Now, as citizens, I think a lot of people would just say, well, maybe we should decide who we like. Do we like California better with its politics? Do we like the Trump administration better with its politics? But as lawyers, what we're looking at is, what does the statute say, right?
So maybe the place to start, though, is all the different standards that regulate automobiles that are environmental standards, and just kind of lay those out. So Ben, you've mentioned the emissions standards, but there also are these CAFE standards, which aren't really, those aren't about emissions, right? Those are about fuel economy. Do they have that right?
Yes. So it's interesting. We have EPA under its Clean Air Act authority regulating emission standards, and then we have another agency, the National Highway Traffic Safety Administration, Nitsa, as we affectionately call it, which sets vehicle mileage standards, and those are really about efficiency. So remember back in the 1970s, we had an oil crisis, and Congress said, hey, we need to get the mileage standards up a bit. So that agency sets mileage standards. EPA standards and California standards are sort of grams of pollutants emitted. So those are two separate sets of standards that need to come together. And in fact, under the Bush administration, there was a big deal where all the agencies in California and the automakers got together and agreed to a single set of standards.
But now that single set has been kind of torn asunder a little bit because, as I understand, last year, the Trump administration came out with a new set of proposed regs. And can you describe those?
Yeah, so the way these standards get set is kind of on these rolling 5-year basis so that the auto industry can plan its production for the next 5 years. And so we had this big deal, and during sort of the 2012 to 16-17 period, the standards ramped up very slowly. But then we hit this period where they're supposed to ramp up very quickly. So we're supposed to get, by 2025, we're supposed to get up to close to 55 miles per gallon as the corporate fuel economy standards. And that's not every car gets that. It's across the vehicle fleet.
But that would mean that some of them would have to get a lot more than that.
Yes.
So that would mean using electric vehicles?
Exactly. So that's where California is going, is to try to really goose the electric vehicle market to really get that up, because the only way to really reduce greenhouse gas emissions, as opposed to these other traditional pollutants, is to either switch the technology or get very high gas standards. So,
And to get the very high gas standards without switching the technology, you have to get very teeny cars?
well, no. So I think that's a bit of a myth. But obviously, cars are getting more and more efficient as the manufacturers respond to regulatory incentives. And so what the Trump administration has proposed is to actually freeze, when we're right about at the curve where we're supposed to ramp up, to actually freeze the standards in place. And so that's the big controversy at this point. And so on one side, it's there's concern about the cost of cars and all of that. On the other side, I think there are good arguments for keeping the standards in place, but that's the fight that's going on.
And so let's kind of elaborate on that. The Trump administration, as I understand it, makes an argument that goes something like this. It's expensive to increase fuel economy, and if cars cost more, then people won't buy the new cars. The new cars are safer. So if people don't buy those safe new cars, they're driving in unsafe old cars, and people will die because of the new standards. And they have hundreds of deaths each year, I believe, maybe even thousands, that they're arguing. And I don't know, that sounds, dying in an auto accident sounds really bad to me. So I'm guessing you're on the other side, so respond to that.
Yeah, so that is the analysis that the Trump administration did. There was an analysis right before the Obama administration left office, kind of doing a mid-course check-in, saying yes, we're on the right curve upward, and considered those safety issues. So the Trump administration's come back with this safety argument. So a couple of things: people die in automobiles every year. I won't take on the 1,000 versus 100. I'm not sure, but let me just give you the argument on the other side, which is what the Trump administration is doing is omitting two very important costs on the other side. So one is greenhouse gas emissions and the social cost of carbon that people talk about, which is what are the impacts on all of us, human health and the economy, as a result of continuing to have these high carbon dioxide output. The other is the conventional pollutant side. So LA is a lot cleaner. I grew up there too. The smog was palpable, but it's still the dirtiest city in the nation, and we still have conventional pollution problems. And if you increase mileage standards, you continue to improve health impacts, particularly in areas like Los Angeles and the Central Valley of California, where we have very low income populations exposed to very dirty air pollution there.
This is Stanford Legal, and today we're talking with our guests, Ben DeGolia and Debbie Sivas, about environmental law and where the Trump administration is going with the regulation of vehicles. And your response to Joe, Debbie, brings up a question that I think those of you who are environmental law have to wrestle with all the time, which is the idea of statistical lives and figuring out, 1,000 people might die if they drive older cars, and 400,000 people might have 6 days less of life expectancy if there's more pollution. How do you guys think about that, and how do you deal with it as lawyers?
Well, this is not exactly the area of expertise that I've focused on with respect to this issue. And I frankly think it's a balancing act. If there are real costs on both sides that policymakers have to think carefully about. I think that we should also scrutinize the figures that the Trump administration has come up with here and the methodology that they've used to get to those figures. So the California Air Resources Board, in its comments to the notice of proposed rulemaking that the Trump administration released last August, showed that the Trump administration's, the Trump EPA's model that it used to predict the number of kind of increased deaths and increased cost from more fuel efficient and less emitting vehicles was flawed in some really significant ways. And in fact, it pointed out that the Trump administration itself, when it put together this model, noted that there were some really serious flaws in the model and some of the internal conversations that they were having at the EPA. So I think when there are true costs on both sides, policymakers have to balance those. And I think you're right that in environmental policy, that's something that we deal with really frequently. But we also should scrutinize whether those costs are real.
It's really hard for the average person to kind of play in this league, I think, because I know there was an article in Science magazine that was critical of the Trump administration's methodology. For the average person, that's putting an awful lot of work into figuring that out. And I guess what people do these days is, for better or worse, they just retreat to their political priors. I believe these guys or I don't.
So how do you see your job as environmental lawyers? Is it mostly standard lawyering? Is there a lot of stuff that's not standard lawyering, that's more public education? How do you kind of think about the tools that you have available for dealing with something like the Trump administration's attempt to roll back the standards?
I think we use all the tools that lawyers get used to, and I think in the environmental field that's always true. So obviously there's the traditional litigation route. There will be big lawsuits if the Trump administration follows through with its plan to roll back standards and revoke the waiver. California will be involved. A lot of the other stakeholders will be involved, and we, as even in our own clinic, have been involved in some of that litigation. There are, policy papers. There's trying to change legislation, which is another way to deal with this, and have a legislative policy, be the driver. There is media. There's this back and forth in the media, and I think all those skills are very important for lawyers who are going to work in these complex areas to really develop and use to the fullest extent.
And how do lawyers develop those skills, actually?
Well, partly we do it in legal training in law schools, right, and in the clinical program. So Ben's been involved in that and can speak to that. But we try to give, through our program here, we try to allow students to really act like lawyers before they're even out in the, members of the bar, and in terms of writing briefs to the court, standing up and arguing. We have students have argued some of these cases in court, writing policy papers, dealing with legislatures and all of that.
Can you tell us a little bit about the clinic?
Sure.
Yeah.
Yeah, so we do work on these issues and a whole variety of others. I'll just mention one case that we were heavily involved in a number of years ago. Students were very involved in, and that was it was the Center for Biological Diversity versus Nitsa, and that was the case that really set this notion that an agency has to consider the social cost of carbon. We were challenging some of the very early CAFE standards from Nitsa, had never been challenged in an environmental forum before, and we said you have to look at the social cost of carbon. And the Ninth Circuit agreed with us, and we brought that case. And then once we brought it, a number of the big environmental NGOs signed on, as did the state of California. So that was kind of a fun thing where students were really on the cutting edge. So we do stuff like that. We do smaller stuff too, but we try to pick a few things that are really of national significance.
Yeah, and without obviously revealing privileged attorney-client information, Ben, what have you worked on in the clinic?
Well, actually, everything that I worked on is public record. So I worked on a number of cases, some state cases and one federal case, which was really cool. I got to argue a summary judgment motion in the Northern District of California federal court in an Endangered Species Act case, where the clinic was seeking to protect the sage grouse and the Trump administration was kind of reversing their prior protections of the sage grouse.
And tell us a little bit about that case.
Well, so this was a distinct subpopulation of the sage grouse that lives along the California-Nevada border. It's a very interesting bird. I would highly recommend everyone to go on YouTube and look up the sage grouse. And it's a bird that is really dependent on a pretty fragile ecosystem. And so throughout this area of Eastern California and Western Nevada, there's been a lot of logging, a lot of mining activity, and other activity that's disrupted the sage grouse habitat. And so the Obama administration listed the sage grouse as threatened under the Endangered Species Act, and then the Trump administration reversed course. And so the clinic filed suit on behalf of our client, the Center for Biological Diversity, and I argued the case, basically arguing that the Trump administration was abdicating its responsibilities under the Endangered Species Act. And we won, so that was pretty fun.
This is Stanford Legal, and today we're talking with Ben DeGolia and Debbie Sivas about environmental law, fuel efficiency standards, regulation of automobiles, the sage grouse, and the Trump administration, not necessarily in that order. Joe?
What was it like? Was that the first argument you've made before a court, Ben?
The first and so far the last.
And what was it like?
It was nerve-wracking and exciting. Honestly, it was thrilling. I got to go up there and argue against the Justice Department lawyer, and won, which was really cool as a second-year law student. The preparation was incredible. I worked with Debbie along with other professors at the clinic who went through probably over a dozen moots with me. I got to argue in front of a number of professors over and over again with my fellow students. And so I felt really well prepared by the time I actually got in there, but it was a lot of work.
I bet. Now, Pam, you've argued about 9 or 10, eight Supreme Court cases. Do you still remember the first case of any sort you argued?
Oh yes, yes. You never forget your first case. My first argument actually ever, I think this was my first, I flew down to New Orleans to argue a motion to dismiss in a voting rights case. And when I got down there, the judge said, is there anything that people want to add to their briefs? And so the lawyer who had moved to dismiss the case got up and began to talk. And the judge said, that's in your briefs, I don't need to hear that again. And then the lawyer said something else, and the judge said, that's in your briefs, I don't need to hear that again. And so then he turned to me and said, Ms. Carlin, do you have anything to say? I said, it's all in my briefs. And I got back on the plane and I flew back to New York. That actually turned out many years later, about 4 or 5 years later, to be my first Supreme Court argument. And I got to say more in the Supreme Court than I got to say in the district court, and ultimately we won. But I still remember it. I still do.
Well, it says something about brevity and wit, I suppose.
Yeah, less is always more. We're going to be back with more from our guests, Ben DeGolia and Debbie Sivas, after we take a break, talking about environmental law. Next, on Stanford Legal, here on Sirius XM, Insight 121. Welcome back to Stanford Legal. I'm Pam Carlin along with Joe Bankman, and today our guests are Ben DeGolia and Debbie Sivas, and we're talking about environmental law. Joe?
Ben, you're working on an argument that says the Trump administration can't take away California's waiver, because California's kind of led the way on stricter environmental regulations. What does it mean to work on that argument? Can you kind of take us through what you're doing?
Yeah, so this is an argument that I'm making on as a part of a directed research project, which is a class that I'm taking for credit with Debbie. And I first became interested in this idea actually as a 1L when I took Debbie's class on US environmental law under the Trump administration, which sort of surveyed transitions that are happening in the Trump administration in environmental law. And I became really interested in the vulnerability of California's existing waiver to set its own vehicle emission standards under the Clean Air Act. And so over time, my interest sort of narrowed, and I decided to focus my research on the question of the sort of threshold question of the legal authority of the Trump administration to revoke a waiver that it already granted several years ago. So that's what I've been focusing on, and the shape that takes for me is basically reviewing all of the regulatory materials So all of the materials from the Trump administration, the responses to the Trump administration's proposed rules from the California Resources Board, from industry groups, and then kind of formulating an argument in the form of a paper, which I've worked with Debbie on, sort of as I've developed the paper.
So did you come to law school knowing you wanted to be an environmental lawyer?
I knew I was interested in either environmental law or public defense, criminal defense. And I took classes in both and became really fascinated by environmental law. I think it was a good balance for me of my intellectual interests and my kind of personal interests in spending time in wild lands. And so it was a good fit for me.
And what are you kind of hoping to do with the paper? Are you planning to publish it or turn it into a legal brief in a case? How do you see the paper going forward?
I think my goal is to try and submit it for publication. A number of agencies, the states in particular, and some independent research groups have looked a little bit at this issue. So there's some briefing on it already, but I've come up with what I think is a novel idea that I'm trying to submit for publication.
And can you share it with us if we promise not to tell the other side?
Yeah, well, I can tell you a little bit about it. So I became really interested in this in part because I had worked on the California waiver issue in bits and pieces since I was a 1L. So I worked on it a little bit at the California Attorney General my first summer, and then I worked on a little bit as a 2L. And in the course of my work on it, it struck me that most people who are working on this issue have seemed to kind of assume that the Trump administration does not have authority under the Clean Air Act to revoke an existing waiver. So a little bit of history, the waiver provision has existed for about a half century. In that time, California has been granted 50 waivers and denied a waiver only once. And that denial was by the Bush administration in March 2008, and the state of California filed a lawsuit, but then that suit was mooted when Obama came into office and they reversed course. So there's never really been, a court has never really evaluated whether the EPA can, or what kind of the criteria are for EPA to deny a waiver, and it's certainly never evaluated whether EPA can revoke a waiver. But the statute doesn't really give much clarity on the power to revoke a waiver, and in fact, courts, the courts of appeals at least, have generally applied a sort of default presumption that where the statute doesn't provide a clear reconsideration provision, the agency has authority to revoke its prior action subject to lots of constraints. And so I've been digging into those constraints a little bit, and in particular, I'm arguing that where federalism concerns are an issue, where there's an issue between federal and state power in an agency adjudication, that inherent authority to reconsider should be significantly limited.
That's a fascinating argument, and it shows something that I think is one of the things that's really important for good lawyers is to be able to work across different areas of law, that what you're really doing is you're taking an area of constitutional law that generally doesn't really operate very much in administrative procedure or even perhaps in environmental law, and using that in a really clever and innovative way to bring about the sort of, if you think back to the old statement about the states being the laboratories of experiments in democracy, what you're really claiming is this is one of those areas, and that's a really fascinating way of thinking about this. I look forward to reading the paper when it comes out. Well, we have time for some questions as well from our audience. So Sharon will bring around the microphone.
Yeah, I'd love to follow up on what you just mentioned, sort of the laboratories of democracy notion in regard to the Clean Air Act standards. I know a lot of environmental statutes sort of have federalist exceptions, letting states set their own water quality standards and things like that. But it seems like in the air quality case, it's rather than sort of creating a diversification of approaches, it's created a consolidation because of manufacturing capabilities, the desire to sort of manufacture something that would meet 40% of the country's needs and things like that. And I'm sort of wondering what sort of room is there for innovation in in this type of legal system where if you do have states with higher standards, there's this strong incentive for that to be the approach, across the entire country.
Yeah, so you're absolutely right. So it's this notion of cooperative federalism that's embedded in a lot of our environmental laws to say we'll set some floor standards, some minimum standards so that the public health is protected across the nation, but we'll let states innovate and do more stringent things so that we can drive innovation. And that applies to a lot of things. Here in the vehicle context, of course, vehicles move around, so they don't stay in one state. And that's one of the reasons why the Clean Air Act set these uniform national standards, but then gave California the ability through this waiver process to really carve out things. And I would say it's been going back to being successful, right? So you all are too young to remember, but the catalytic converter was a revolution in vehicle emissions problems. And that was driven solely by California having more stringent standards and manufacturers trying to meet those standards. And then California is a big place. It's got a tenth of the population or something. So, the industry decided, well, we need to do that across the nation, and that was adopted. So that is actually how it happens even for lots of other kinds of pollution too. And that's why it's so important that that this waiver stay in place so that California can really drive. We are driving the electric car market. And if you ask those in the climate policy field, that's where we need to go, and we need to allow that technology to spread out across the nation.
Yeah.
Thanks. Could you talk about how the fuel economy standards, like the miles per gallon, are set? Like, do the car companies and the environmental advocates go into a room and sort of say, you can do this, or how is that set?
Yeah. Yes. So it's a lot of it is technology and science based, right? But as I mentioned earlier, there was this big deal that was crafted when Obama came on board, and that was driven by a lot of things. One of the things to remember is that we were in the recession, and 2 of the 3 car companies were being bailed out by the federal government. So there was a fair amount of leverage for the incoming administration to actually get people in a room, and there's people who've written about this. About sitting all those stakeholders down in a room. That's normally not how it's done. There's normally a very drawn out kind of administrative law process where everyone gets to submit comments, and all the different stakeholders, hire their experts to submit technical comments and legal comments. And then the agency ultimately decides, often driven by the politics of the agency, but it has to be based on the information that's before them. So it's a little unusual that we had this big deal that the automakers now want to break because they've got a more favorable administration on their side. But so normally it's a long, kind of administrative process, and there's a big record that's created.
We have time for one very last question. So.
Hi. So I'm just kind of curious about the volatility at this level of policy, and just kind of what are places where the Trump administration could do some really permanent damage, and what are things where people would just are gearing up for future administrations and future lawmakers to hopefully reverse course.
So good but short answer.
Okay, really short answer. So yes, this is actually one of the areas where there could be long-term impacts because the manufacturers plan out long-term. So there's other areas where things, a new administration could pretty quickly reverse things. So it's those things where there's a longer horizon, and we'll lose a lot of time in trying to get more stringent standards in place.
Well, you've been listening to Stanford Legal. We've heard our guests, Debbie Civis and Ben DeGolia, talk about the question, is California going to be able to continue to lead the way on fuel economy, on emission standards, or is that right going to be taken away from us?
So thanks for joining us here on Sirius XM Insight 121.